Hello, everybody. So I'm carrying on with adverse possession. So registered land with 12 years adverse possession prior to the 13th of October 2003 is a different situation. Now, this goes back to the Land Registration Act 1925 before the 2002 one was passed. So in the old case law, the lapse of time did not extinguish the owner's title. After 12 years of adverse possession, the registered proprietor was still on the register, but the squatter had an overriding interest, which he could protect on the register. So under the LRA 1925, the registered title was held on statutory trust for the squatter, as per section 75.1. The squatter could apply for registration of title after 12 years, and that's as per section 75, and make a statutory declaration and produce sufficient evidence. The land registry would then give the squatter a possessory title and treat the application as though it was a first registration, but subject to any interest in land which had not been extinguished by adverse possession, for instance, restrictive covenants. In central London commercial estates against Kato Kagaku, a squatter of a car park, Kato, had done his 12 years but were not registered. The tenant surrendered his registered title to the head lease of the car park to the freeholder, but that was ineffective because Kato had adverse possession of the land and therefore had an overriding interest, as per section 70.1f of the old LRA. Because the squatting on registered land is very different from on unregistered land, the squatter is entitled to be placed in the position that was previously occupied by the proprietor. But many people criticised this, and the Law Commission said it wasn't satisfactory. They said that imposing a statutory trust made the situation confusing and unduly complex. So it's done away with, and the new mechanics of this new scheme was introduced. In Markfield Investment against Evans 2001, a court thought about what kind of actions would prevent time running. What would prevent a squatter from building up time towards the 12 years? It was found that bringing an action for possession did not in itself prevent the time running. The action must be carried to completion before then it has any effect. So how about leases? Well, leases under the LRA 1925 in registered land were very different from in unregistered land. In registered land, adverse possession didn't destroy a title because it caused it to be transferred to the squatter. Where an adverse possession barred the tenant of years from registered land and then obtained registration as a proprietor of the leasehold interests, there was no subsequent surrender of the ousted tenant's lease and could enable the freeholder to evict that person. Now look at Spectrum Investment Company against Holmes 1981. Here a tenant was the registered proprietor of a 99-year lease. A subtenant remained in occupation without paying rent for 17 years and became registered the proprietor of the leasehold title. A surrender by the tenant was ineffectual because it was not a registered disposition. Registration of the squatter's title gave the powers of disposition of land to the registered proprietor, i.e. the squatter, and he held them solely, and therefore took those powers from the ex-proprietor, i.e. the tenant, who lost his place in the register. Fairweather against St Marylebone Property Company Limited 1963 is a similar case. So the doctrine of spectrum was taken further in Central London Commercial Estates against Kato Kaguki 1998. A tenant can secure title against a landlord by staying in possession of the land after the end of the term without paying further rent, and that was laid down in Williams and Jones. So how about adverse possession and human rights? In J.A. Pye Oxford Limited and Graham 2001, the Court of Appeal thought about whether gaining land by adverse possession breaches the human property rights of the dispossessed. It was ruled that the removal of title by limitation defines the terms on which an ownership is permitted by English law. So it's not an interference nor a deprivation of the owner's possession of land. The court allowed that an interference with the paper owner's right of access to a court under Article 6 of the European Convention on Human Rights, but regarded the interference as permissible in view of the time limits. So this question has been revisited by the European Court of Human Rights. In J.A. Pye Oxford Limited, the court, first instance, held that the deprivation of registered title to land under the Land Act 1980 and the LRI 1925 was a breach of Article 1 of the First Protocol of the European Convention on Human Rights. The court said its decision was due to a lack of compensation and there weren't sufficient procedural safeguards for the registered title holder. The United Kingdom appealed successfully to the Grand Chamber of the European Court of Human Rights. The Grand Chamber found there was no violation of the convention in J.A. Pye Oxford. So Ofule and Bossert 2008 is a case where the Court of Appeal held that the law of adverse possession doesn't violate human rights, and the decision of the Grand Chamber in Pi must be adhered to unless there were very good reasons for not. And it would seem that the doctrine of adverse possession doesn't breach anyone's human rights. So Oliver Radley Gardner in Webb, in that case, and various other academics have concurred. So anyway, coming on to registered land under the Registered Land Act 2002. So what is adverse possession under the LRA? So the LRA, the new one, makes it much harder for adverse possession to succeed in registered land, and these are the changes. Adverse possession can't be taken from an earlier squatter except where one successor to another, having purchased or inherited the land. That's paragraph 11, section 6. So the squatter can leave the land for a period of one, giving it to another squatter, and then return immediately. Okay, the period of adverse possession before registration can be sought is now 10 years. But a mortgage charges as a registered estate, there is no period of limitation in relation to the redemption. This is a big change in the law. A lender in possession will never bar a borrower. Adverse possession of trust land can't operate unless the interest of each beneficiary is in possession. There are three cases where adverse possession is probably going to succeed against a registered proprietor objection. These are estoppel, independent entitlement to estate, and boundary disputes. In each situation, the squatter gains rights and independent fee simple and therefore becomes registered as a proprietor. So let's look at estoppel. Paragraph 5.2 of Schedule 6 of the LRA. An adverse possessor can demand on registration that it be unconscionable for the registered proprietor to dispossess him. And that's quite simple. How about an independent right to an estate? If the squatter separately has a proprietary claim to the land, for example, they've agreed to purchase it or have taken occupation, he will be entitled to seek registration as per paragraph 5.3, Schedule 6 of the LRA, 2002. Bear in mind that neither this nor the previous situation, estoppel, exists if the squatter's claim is due to some separate basis, such as adverse possession. You can see Updating the Land Registry Act 2002, that's a Law Commission report, and they said that the adverse possession provisions in the LRA 2002 to determine the strengths of other claims to land might be useful, but conceptually they were just not good enough. But after this consultation exercise, the Law Commission said they were not going to suggest any changes in those categories. Well, on to boundary disputes. This is when they're arguing about where the actual boundary is. Okay, so it's quite common that the fence is not where it should be. The land registry only gives a broad boundary line, and the details and the enclosures, the fences and so on, they fix it. An adverse possessor will become the registered proprietor of any strip of land as per paragraph 5.4 Schedule 6 if he owns the adjacent land from which the application is made. The exact boundary line hasn't been demarcated clearly. The applicant has held adverse possession for 10 years at the date of the application, and throughout that time the applicant or his predecessor in title reasonably believed that the land belonged to him. The estate to which the application relates was registered more than a year before the application. So you have to bear in mind that whether the applicant's belief is reasonable or not, it's their knowledge that matters, not the knowledge of the agent, such as a solicitor. And that's not going to be imputed to them as per IAM Group and Chowdhury 2012. That the registered owner has argued against the squatter's entitlement might not overturn the reasonableness of the squatter's belief. The necessity of the period of reasonable belief has to last over 10 years. At the end of the date of the application has been something which is contentious, and judges have sometimes said this isn't good enough. At the moment, the prevailing view is as per Lord Justice Arden, that a reasonable belief doesn't have to continue right up to the time of the squatter's application for registration, provided it was reasonable at the beginning. So Zarb and Parry 2011 is a case about that. Is this too brief? Well, their exception is limited in scope. It's applicable only to true boundary disputes where the whole of the land or a major part of it is adjacent to the squatter's land, as in Dowse against Bradford Metropolitan District Council 2020. So how does adverse possession work under the LRA 2002? The Law Commission's aim was that adverse possession of estate and land will never be a bar on registered proprietor's title. Possession for any period of time won't automatically extinguish a title as per section 96.3 of the LRA. A person who's been in adverse possession for over 10 years can apply to be the registered proprietor as per paragraph 1.13 of Schedule 6, and he'll usually be in possession at the time of the application. But when they receive it, the registrar will notify the registered proprietor, who probably say no within 3 months. That's as per section 3.2 of Schedule 6. The proprietor of any registered charge of superior title, or any person who is registered to receive any such notice, will also be informed and will be able to object. If no objections are found, the adverse possessor is going to be registered as the new proprietor of the title. If objections are put forward, then the adverse possessor's application is automatically rejected. But none of the exceptional grounds in sections 5.2 to 4 are there. The applicant can remain in adverse possession for more than 2 years. The applicant can make more applications to be registered. And on receiving a second application, the registrar must register the adverse possessor as the proprietor. The adverse possessor will take the title, but this is subject to any existing priorities, but free of any registered charge. There's no crossover period for existing squatters unless they've acquired their full rights through their 12 years possession before the 13th of October 2013. Therefore, a squatter with 10 years, well, sort of 12 years less than 1 day possession, is governed by a completely different set of rules, and is probably not going to gain registration. But they will have an overriding interest if he's in actual occupation. Adverse possession has some role as a perfecter of title in all but 3 unusual situations. For instance, if the proprietor vanishes, adverse possession, therefore, it undermines the mirror principle of the registrar, and it implements changes by the LRA 2002. And this supports the conclusiveness of the registration. Voluntary registration of title will defeat the adverse possessor's rights. That's a very cheap thing to do, and the land doesn't have to be registered throughout the 10-year period for this mechanism to operate. In unregistered land, well, this is not affected by the changes because the 12 years adverse possession, as per the Land Act 1974, Section 15, the paper owner's title will be extinguished, as per Section 17 of the Land Act 1980. The adverse possessor can apply to be registered. Possessory title will be granted, and absolute title can be applied for once a possessory title has been registered for 12 years or more, as per Section 62.4 or 5 of the LRA 2002. So that's enough.